before the debate on the bill resumes.
Secretary for Justice. President, I move that the Arbitration Amendment Bill 2021, that is the bill, be read a second time. The main object of the bill is to amend the Arbitration Ordinance Cap 609 to fully implement the supplemental arrangement concerning mutual enforcement of arbitral awards between the mainland and the Hong Kong SAR. That is the supplemental arrangement signed between the governments of Hong Kong SAR and the Supreme People's Court of the People's Republic of China on the 27th of November 2020. The purpose of signing the supplemental arrangement is to amend the arrangement concerning mutual enforcement of arbitral awards between the mainland and the Hong Kong SAR. That is the arrangement, which came into effect on the 1st of February 2000. This will bring the arrangements more fully in line with the current practice of international arbitration. In doing so, reference has been made to the implementation experience accrued over the years and the comments from the arbitration sector. The amendments contained in the supplemental arrangements were made in alignment with the spirit of the New York Convention and do not constitute any major change of policy. The supplemental arrangement amends the arrangements in certain aspects, for example, redefining the scope of arbitral awards with the seats of arbitration and removing the previous restriction of the arrangement, thus allowing parties to make simultaneous applications to both the courts of the mainland and the Hong Kong SAR for enforcement of an arbitral award. This is in line with the current practice of international arbitration under the New York Convention. To implement the above amendments, it is necessary to amend the Arbitration Ordinance. Following the completion of the relevant internal procedures in the mainland and the Hong Kong SAR, both sides shall announce a date on which the provisions of the supplemental arrangement shall commence. The Advisory Committee on Promotion of Arbitration was consulted by the Department of Justice. The Advisory Committee unanimously supported the signing of the supplemental arrangement and the related proposal to amend the legislation. The signing of the supplemental arrangement is also generally welcomed by the legal practitioners and arbitration community in Hong Kong. The Department of Justice briefed the Panel on Administration of Justice and Legal Services of the Legislative Council on the signing of the supplemental arrangement and the proposal to amend the Arbitration Ordinance to implement the supplemental arrangement at its meeting on the 27th of January 2021. Members of the panel are content with the proposal, and the Hong Kong Bar Association also expressed support at the meeting. In addition, the Law Society has also sent a letter to the Department of Justice to give its support to the supplemental arrangements and urge the government to speed up the procedures. The bill amends the definition of mainland award and repeals the definition of recognized mainland arbitral authority in Section 2 of the Arbitration Ordinance. Section 97 of the Arbitration Ordinance is also repealed. The effect is that as long as an arbitral award is made in accordance with the arbitration law of the PRC, it may be enforced under the AO Arbitration Ordinance regardless of whether it is made by an arbitral authority specified in a list published under Section 97 of the Arbitration Ordinance. The need to publish such a list is accordingly dispensed with. The bill repeals Section 93 of the Arbitration Ordinance to remove the restriction under that section on the enforcement of mainland awards. The effect is that concurrent applications may be made in the mainland and Hong Kong for enforcement of a mainland award. Apart from the above, the bill also makes minor textual amendments concerning the definition of the mainland in Section 2 of the Arbitration Ordinance and updates the schedule to the arbitration parties to New York Convention Order Cap 609 Subsidiary Legislation A by adding 4 new parties to the New York Convention. President, from time to time, the Department of Justice will review the dispute resolution system in Hong Kong and actively seeks to optimize judicial cooperation in civil and commercial matters between Hong Kong and the mainland. We believe that the passage of the bill will bring benefits to the sector and further consolidate Hong Kong's status as a major hub for international legal and dispute resolution services in the Asia-Pacific region. I so submit. I implore members to support the bill. Thank you, President. I now propose the question to you that the aforesaid bill be read the second time. In accordance with the rules of procedure, the second reading debate is adjourned and the bill is referred to the House Committee.
勞工